So I think we can probably just jump to the first slide. So I touched on this briefly about the differences between native title and cultural heritage. So they are governed by two completely different pieces of legislation. And the important distinction is that native title is a Commonwealth legislation, which means it applies across the whole of the country exactly the same way. So it doesn't matter where you are in Australia, the native title requirements and steps and processes apply exactly the same. Cultural heritage is actually specific to each state. So each state has a different cultural heritage regime on how they manage and protect their sacred sites and sacred areas. So for those of you who aren't aware, the native title legislation came about from the Mabo decision. So that was the High Court decision in Mabo, where it was the first time that an Australian court had recognised that native title interest, basically law and custom, had existed since the point of first contact with the British settlers, and that the idea of terra nullius was overturned. So when most of you hopefully remember your Queensland, your education in primary school, I think we're taught, that when we were settled, and that there was no one here that had laws and customs as a society, and therefore we were deemed to be terra nullius. So the significance of that decision in 92 was that there was a recognition that, in fact, there were laws and customs and actually societies that existed here at that point in time. So
I think Dwayne calls it boat hit the beach.
when the boat hit the beach.
That's right. Dwayne was a trainer previously as well. So I thought I'd chuck that in there. He'd like to hear that.
So and then the difference with the Queensland legislation is that it applies only to Queensland, so everywhere in Queensland and the Torres Strait, and it relates to the protection of places and things that are significant. So native title deals with rights and interests, cultural heritage deals with places and things. That's probably the easiest way that you can distinguish them. And that the difference is that under the Native Title Act, those rights and interests can actually be watered down depending of the process and the steps that a particular person doing an activity has to follow. Under the Cultural Heritage Act, there is a blanket protection for all significant places and things, and that the duty of care sits with the land user. And next slide, Josh. Is it going to go to the next slide? Yep. Okay.
Does it come up?
Yep, now it has. So briefly, there's a comparison there of the differences between the two. So native title is always described as a bundle of rights, and by that they mean when you are actually going through your native title determination process, one of the things that you outline in your application is the rights and interests that you are seeking to have recognised by the court. And because there are normally a number of things such as the right to have access to your traditional lands, the right to conduct ceremony, the right to protect particular areas of sacred significance, the right to continue to practice ceremony and hand down laws and customs. So there's all of these different rights that you ask for, and they are therefore described as a bundle of rights. Native title also has different, I would suppose, levels of recognition is the way that you could describe it, and that there you have exclusive native title, and that is the closest that there is to freehold. Exclusive native title means that they have been recognised as the traditional owners, and that using their native title, they actually have the right to exclude others from that area. So similar to the rights of a person who has either exclusive lease or freehold. And then you have a lesser level of control, and that is called non-exclusive native title rights. Now, non-exclusive native title rights are normally recognised around areas where there are a lot of pastoral leaseholders, or in relation to areas possibly of reserve from the state for things like education, maybe camping. So there is different levels, and you could have a native title determination that will recognise that in parts of their claim area, they have non-exclusive rights, and then in other parts of their area, they have exclusive native title rights and interests. So there's never native title and cultural heritage is never everything is the same. Everything is completely different. Depending on who you are talking to and where you are, everything will be different. That's probably the safest way to approach it.
Same, but different.
Yeah, same, but different. That's a good way to be going into any discussion.
Just on that, what about urban areas? So cities and things.
So in depending on which city and native title also relates to and is connected to the underlying tenure of the land. So where you have freehold, you cannot have like normal fee simple freehold, you cannot have native title. And that is because one of the tests that they do is that you've got to test to see whether the rights and interests of the native title holders are incompatible with that of the tenure holder. So for a freehold person, the rights and interests of a freehold person where they want to, use and enjoy their land to be able to exclude and control it is inconsistent with the native title rights and interests wanting to access. So granting of freehold extinguishes native title. So in many of our big cities, a lot of native title has been extinguished because of either previous works that have been done in the time they were done, or a lot of the land is already freehold. So in some of the bigger cities, there will be very little, possibly zero exclusive native title. There may be areas of non-exclusive native title, and they will normally be your state forests, your national parks, some areas of, creeks. So in those urban areas, they will have very little native title rights and interests, which they will be able to exercise, but they will still have cultural heritage. So cultural heritage exists regardless of what the tenure is. So native title is linked to underlying tenure. So there's a relationship there. Cultural heritage, no relationship with tenure. So you can have a significant Aboriginal or Torres Strait Islander site on an area that is freehold. You can have artifacts that are found on places that are freehold. It does not matter. So that is another important difference. So cultural heritage relates to, like I said, the places. So those significant places because of their laws and customs, whether they're story places, whether they are places where they're used to conduct ceremony. They might be, if you're living on the coast, they might have fish traps. So it's something that is important to the traditional owners of that area, and that is the key. It's important to them. Only they can tell you whether or not something is significant. That is their responsibility. And it also includes things. Oh, sorry, I'll just go back to places. So it can also have a historical importance. So you might have, so we have a number of mission sites throughout Queensland. They are culturally significant because of the history with the Aboriginal people or Torres Strait Island people for that area. So even though they were removed and placed there and that they may be building an infrastructure, there is a historical importance to that community, which makes that important too. So that also could include massacre sites. If it is important to them because of their history and connection to the area, that makes it important. Is that pretty clear so far? Does anyone have any questions on the distinguishing the two before I go on? You'll have to stop me because I can talk about this stuff all day.
Just
and you will go to sleep. You will go to sleep. So make this is, if you do have something you want me to ask, please sing out now.
Someone in the chat. Oh, Julie, thanks, Julie Coleman says really clear. Thanks. That's good.
Thanks, Julie.
We won't get into some of the other discussions. Cassie has a funny story about things being clear as mud and using words in locations that have a cultural slang meaning that's in a which is probably another thing to keep in mind is that sometimes words that we know don't mean the same in other languages or other countries.
It's very important to clarify that and maybe don't use the colloquialism when you are maybe engaging and communicating because it does get yourself in a bit of a pickle.
From first-hand experience.
From first-hand experience, it can be quite embarrassing.
Okay, so we're waiting for the next slide. It's doesn't want to. There we go.
Okay. So another key difference is that native title rights and interests are recognised by the federal court. So once you get a determination, you get an order from the federal court or the full federal court or the high court, depending on where you go. But you end up with a court decision, which is registered. You can then search them on the federal court website, which outlines and your recognition of your right to that particular area. It outlines the area of which your rights have been recognised. It outlines the rights and interests of which the court and the state and commonwealth have also recognised. And it will also set out whether or not they've recognised you have exclusive or non-exclusive rights. So that comes from the court. Cultural heritage is not, it is recognised and protected under the Queensland legislation. They will give you, it gives you examples of what may be considered cultural heritage. So they talk about artefacts, which could be splints or flakes, from tools that were used, hundreds of years ago. They could be found. It could be wells. It could be quarries. It can be, like I said, it could be trees, depending on if they have a connection to a particular dreaming story. Cultural heritage is a lot broader. And there's not a very strict and easy interpretation or definition that you get from the federal court with your native title rights and interests. So, like I said before, cultural heritage can exist even though the federal court might have said native title has been extinguished. So that doesn't automatically give you the green light to go ahead, for if you were a developer, you will still have to address cultural heritage.
Next slide.
Yes, please, Josh. So again, I talked about this briefly before. So native title recognised is a Commonwealth piece of legislation enacted by the Commonwealth Parliament, applies across the country. Queensland cultural heritage is for Queensland only, passed by Queensland legislation, applies only to Queensland. So both of them, though, recognise, I suppose, Aboriginal and Torres Strait Islander as key in both of their processes. So the Native Title Act, even the preamble, actually goes and acknowledges and recognises the past injustices that Indigenous people have faced, and that the creation of the Native Title Act was supposed to go some way to rectifying and provide that justice. It also aims to balance the competing rights between land users and native title or traditional owners. So there is a process and steps in the Native Title Act that was put in there to try and find a balance between the competing rights. Cultural heritage, basically, it does the same thing. It also has put a process in place to, again, try and balance the competing responsibilities and rights. So under the Cultural Heritage Act, the responsibility to conserve and protect sits with the Aboriginal Torres Strait Islander Party. It also recognises the Aboriginal Torres Strait Islander group as the primary guardians, keepers and knowledge holders of those areas. So there is that level of respect under the Queensland legislation, but it also respects that there needs to be in place a process that enables land users to be able to use the land and work with the Aboriginal or Torres Strait Islander Party to manage and mitigate any harm to places or things that are important. Is that clear? Yeah. Any questions? Next slide, Josh.
Has that one come up yet? It seems to be.
Yep, nope, I've got that one. So under the Native Title Act there, it has basically different sections. So you have your section which outlines the different types of activities or acts, then has a whole section that sets out the process that you need to follow in order to lodge your claim, authorise your claim, lodge your claim, all the way through to determination. It then has a section that sets out the roles and functions of the National Native Title Tribunal. It has a section that deals with the roles and responsibilities of rep bodies across the country, which I don't know many of them read. And then it also has a section that sets out the steps and processes which, if somebody is wanting to undertake an activity or something on an area of land that is covered by native title, they've got to follow. So under the Native Title Act, there we deal with, most of the time, we're talking about things that we call which are a future act. So they are a future act because of how it is defined under the Act. And that is that to be a future act, what you are doing has to be something that affects native title. And the word affect, being a piece of legislation and lawyers love definitions, is also defined. And it sets out in the Act, there's probably, it goes like, A, B, and then each of them have like, Roman numeral 1, 2, 3, 4, 5, 1, 2, 3, 4, 5. So there's all these little ands that sit underneath there. But basically, something you are doing will affect native title if you are creating some type of interest, whether it is in equity, whether it is by contract, whether it is by legislation. So if you are creating a piece of legislation, whether you are amending one that already exists, that affects somebody's native title rights and interest to use their land as recognised under the federal court order, it would be considered a future act. So it also could be, most of the time future acts deal with activities and projects. Most of the time it's about somebody wants to build something somewhere or fix something somewhere, and they do their due diligence, and it comes up saying there is native title here. We have to see which category it fits in, so it tells us what steps we need to follow. Is that clear?
I think just to add to that as well, Cassie, there is questions around the moment around whether a planning scheme would be considered a future act or not.
Yeah.
And it hasn't been tested.
It hasn't been tested.
So there's no definitive response there. But at the moment, the view that's been taken by the planning group is that it is not a future act until such time as proven otherwise. Mm-hmm. And that the reason being is that a planning scheme only identifies a process and outcomes that may potentially occur on that site, but the planning scheme doesn't actually deliver those outcomes that may affect it. So it just sets up the framework. So there is, look, there are very widely varying views on that. But until such time as it's tested, that's the position that the planning group is taking.
Are there any other questions on that before I jump to the next slide? No? Okay. I might get you to talk to this one, Josh.
Okay, no worries. So again, and look, this will be discussed a little bit later on as well in the detail, but there's a question around native title and cultural heritage and what's the relationship between the different legislation. And so, as Cassie said, the native title is quite a high order legislation and applies federally, and it really talks about rights and interests from a cultural perspective that can occur on that land, or may be able to occur, and it's all about maintenance of culture, maintenance of tradition, heritage, all of those types of things, many of which won't be relevant to a planning scheme because it's not defined as development. But what is important is that it recognises the interests of that land. And so the Planning Act itself, the provisions below that are probably quite relevant in explaining some of this, is that it says there that the purpose of the Act is to establish an efficient, effective and transparent, integrated and coordinated system for land use and development assessment, relates to matters that facilitate ecological sustainability. And there's a whole range of other things that sit in that in terms of the purpose of the Act in Section 5 around ecological sustainability, around economics, around social outcomes, and we'll talk about those a little bit later. So there are some overlaps, but in terms of what native title allows for and the bundle of rights and interests is that there isn't a significant overlap there. You do need to, as you're in terms of, as we said, in the context of that definition about development rights, land use planning. But you do need to obviously be aware of it, particularly from a tenure perspective, and also understanding how those rights and interests may be relevant from an engagement perspective and the landowner and a stakeholder perspective, I guess you would say. And we'll talk about that a little bit later on. What we did mention in terms of cultural heritage as well is that there is an act that governs the artefacts and places. And I think I said right back at the very start, and we'll talk about this a little later on, is that that provides blanket protection of those artefacts and things. So many of you would probably be familiar. I'll give you an example where if you get a development approval, one of the conditions as an advisory note is that you need to have regard to the Cultural Heritage Act. The Cultural Heritage Act sets up a duty of care and sets up other provisions and systems that enable those places to be protected. So, to date, the approach for planning scheme preparation is that Cultural Heritage Act, both the Aboriginal and Torres Strait ones already address that. So there's no need to duplicate effectively, but there can be a reference made to those. So I think it is important to be aware of them, and it is certainly important from a stakeholder engagement perspective, and that engagement will then talk about the aspirations of those people. But in terms of how it actually lands, there might be, there's kind of nuances that you need to deal with. I'm just looking, Julie Coleman's also raised something that Cassie will love because she's going to talk about this in a minute, is Julie says, there is also significant overlap with the Human Rights Act consideration, section 28. And I see Cassie laughing already because she loves getting this in here. So Cassie, I don't know whether you want to talk about that now or whether it happens a little bit later on. Look, that just, sorry, before we get to that, that just covers off on some of the points that I've already raised around the purpose of the Planning Act. It also has a provision in item D that talks about conserving place and cultural heritage significance. And obviously the state planning policy also talks about cultural heritage, but in the sense of, again, that those relevant acts provide blanket protection. And we'll talk about that in a little bit more detail later. Here we go. Look at that. Isn't that amazing?
Here's one we prepared earlier.
Okay, away you go. I'm done.
This is actually one of my favourite parts of the presentation. So, for those of you who are unaware, that from the 1st of January this year, the Human Rights Act actually came into force, and there is actually a section in that act that recognises, which is actually set out on the PowerPoint slide there, which recognises the human rights of Aboriginal and Torres Strait Islander peoples to maintain, protect and develop their traditional laws and waters. And what is actually significant, and one of the reasons I love talking about this section, is that it actually reflects Article 31 of the United Nations Declaration on the Rights of Indigenous People, which Australia became a signatory to in 2009. So I love talking about this section. I love using this section wherever I can, because it just reinforces what we've just spoken about in relation to cultural heritage, but it also then ties in the connection between native title rights and interests and the protection, how they use those laws and customs to then protect those places and things that are of significance to them. But it also goes further and talks about using the environment to also create for as part of their identity and strengthen their material and economic connection and relationship with their land and territory. So I do love this section. I do use it a lot. And like Josh said, I can't wait to get here. And sometimes I end up bringing it in much further on in the presentation. So I thought I did pretty good today, Josh. I actually waited till I got to the slide to talk about it today.
That's right. Julie, are you there? Do you want to just make comment as well on what your views are around that?
Yep, sure. Sorry, I came in very late to the meeting because I had technology issues. So forgive me if I've missed the meeting etiquette from the beginning. The only reason I raised it is that we've been particularly considering the human rights implications recently. We've gone through a process of reviewing our regulation. For those of you who don't know, Wet Tropics Management Act is a regulation under our Wet Tropics Management Plan is a regulation under our Act. So as going through the process of reviewing that plan, we've written a human rights certificate. So of course that's brought the consideration about human rights to the forefront of our mind. And now we're going through the process of working out how to integrate human rights considerations properly in the general work we're doing in our office. So given that we have introduced the consideration, the separate consideration of Aboriginal tradition into our plan, and we're trying to look at how the various pieces of the legislation fit together and how the considerations under our plan can incorporate the other requirements of Native Title Act and then the Human Rights Act. So this is pretty forefront in our mind at the moment. I don't have any particular wisdom to share at this point, but that's where that consideration came from.
I would say, I think if you find what I'm finding also is that when you are dealing with some government departments too, when you are you're putting submissions or asking for, if you're following a process under that, for example, a recent one I had was I was working with a group and we wrote to the Cultural Heritage Unit within DATSIP and asked them to register the PBC as the registered Aboriginal Cultural Heritage body under the Act. The response we got was, thank you for your application and submission. We are currently considering our responsibilities under the Human Rights Act and how that interrelates with this. So I'm actually getting a lot of responses from government when we're asking them to do something or implement something under a particular piece of legislation, that the common response is, thank you. We're now also going to be considering how that relates in the interrelationship with the Human Rights Act.
Yeah, which is interesting because we started this journey of training at the start of the year, and this was a very new concept at that point in time. And Cassie was saying, well, it'll be interesting to see how it plays out. But I certainly think, and would be interested to hear the views of others, is that that the outcome sought by the Human Rights Act and a planning scheme in terms of how it may or may not regulate traditional rights and customs, and also development aspirations for that land, and kind of, for example, getting back on country and that type of thing. Be really interesting to see the interrelationship between those. I don't know, Brett, I'm going to single you out here, whether you guys up there have had any exposure to any of this, or what your particular views or emerging patterns are around how people are addressing the interrelationship between the Planning Act and the Native Title and Cultural Heritage Act?
I don't have an answer, but I did, as that discussion was happening, write down a note to myself about, what is the impact on human rights, particularly on this human right, when a planning scheme is being implemented that might provide for development in an area that wasn't previously provided for. So I think it would be fair to say it's not something that's coming up regularly at the moment. Most of the human rights considerations I'm seeing, and I think are being given thought to, are things about property rights, rights for free movement, etc. But I think this is probably an area we need to give more thought to in how, in the human rights considerations when planning schemes are being implemented.
That's really useful, Brett, and something that also comes to mind for me and needs further further investigation and thought is in terms of engagement processes and making sure that you're engaging with the right people and kind of their rights and ability to be heard, and the importance of that is probably something that's relevant and could be stitched nicely into this too. You know, I mean, everyone has a right to have a say on a planning scheme, absolutely. And there's some stakeholders that have particular interests. So it's about making sure that you know, their right to have a say on their land and related to their you know, as I say there, their cultural practices and that type of thing, I think will be particularly important.
Yeah, I think there's probably still lots of things to consider in terms of how we appropriately give those human rights considerations through planning.
Absolutely. Big stuff. Look, we might keep going. Cassie, I'll flick to the next slide for you, unless anyone else has a question or wants to continue that conversation. We'll give you guys a break from text heavy. I apologise for that too. It's a lot to get through, but Cassie will explain this fabulous map and we'll move on from there.
So I do love this map. So this is a great map to show, or as a picture to demonstrate the extent of native title across the country. So you'll see that I just have to make the map bigger on my screen so I can tell you the colors, but it should be that the dark green areas are where native title has been recognized. Same with so this is, I've actually got one where you can go onto the National Native Title Tribunal's website and you can actually get different maps that show different types of, I suppose, rights and interests. So you could get one that shows just for your state, you can one for just the whole of the country, which talks about all of the native title determinations that have been made, where all of the PBCs are and the type of landholding that they have, the current native title claims that are on. So this is one that shows all of that combined on where native title has been extinguished. So
Cassie, on that as well, what we'll do at the end of this session is we'll get Cassie to jump on and share her screen and show you guys how to operate that.
Yeah, okay, I can do that. So this is just at a glance, can just show you like where the native title, what the native title landscape looks like across the country. But I think once we jump to the next one, Josh, which is the one about just Queensland. This one is, so the green, that's where there are all of the land holdings that the PBCs across the country have. So every bit of green has a prescribed body corporate that holds their native title on trust or as agent. Next one, Josh. Okay, so this is Queensland. So what this map roughly shows is that you can see by the grey areas that they're areas where native title has been recognised. So they're all determinations. And then the colourful still areas are areas where there are still claims. So you can see roughly on that approximately 31% of the state has a determination over it. The other 30-something% is covered by a claim. So they're currently going through the native title process under the Act and in the court to have their native title court recognised. There is also sections within the state that have had native title recognised that native title no longer exists. So it's a negative determination. But the importance of this map is that, you know, within the next 5 to 10 years, 60% of our state is going to be covered by a determination of native title. Now, there'll be some areas that may never ever be covered by a claim because there's just not enough evidence of the history to prove the connection. But there will always be people that, you know, for cultural heritage purposes, will have responsibilities for those areas and things that are important to them under their laws and customs, but it just may mean that they did not have enough evidence or could not provide enough evidence to jump through the hoops that you are required to have your native title recognised by the court.
And I think the other thing that this is saying for us in the plan making process is is that it's really important to understand the lie of the land, so to speak, in terms of what the interests are, because that will really help point you to who you need to be speaking with. It'll also help you to understand what the relationships are between the different groups. And Cassie, you can explain this better than I can. It's a little bit tricky to see because the text is small there. We wanted to keep this more holistic, but there are claims that have been combined, for example, or changed over time. So they may not be just one group. They could be a couple of groups. And one thing that's really stuck in my mind about native title is, unfortunately, there's hangovers and there's winners and losers, and there's a lot of kind of issues associated with native title, and we kind of flag this later, but it's really important to understand the lie of the land, but not necessarily raise it and rehash old issues as you're going through the plan making process.
So I suppose one of the tricky things about native title is there is actually a different understanding of what native title means depending on who you talk to. So the recognition of native title has a different meaning, and many traditional owners have a different understanding of what they believe the act to achieve. And it does cause a lot of frustration when the understanding is that it's supposed to be about identifying the right people for country, and that's not always the case. Because of the history of our state, because of the way that our laws and customs and the intergenerational transmission of knowledge is done orally, there are gaps in some of that evidence, of which the state and Crown law, they have a benchmark of which you need to be able to demonstrate and prove before they will actually agree to recognise your native title rights and interests for that area. Sometimes, as an individual society, you don't have enough to do a claim on your own. So based on some of the research and the work with your Aboriginal Torres Strait Islander representative body, they might put together a regional claim which may be based, for example, on a language group or some neighbouring groups where you have shared areas and you have shared stories and responsibilities for areas that you can then demonstrate that you're a regional society rather than individual societies, which causes its own issues in relation to the implementation or the recognition and responsibilities that then sit for that area. But then also from a practical sense, once you then are trying to make decisions on country, how do you then make decisions if you then have a PBC, for example, who holds native title for a number of groups, but you're recognised in the one determination? So there's a lot of complexities in this space, and it does cause a lot of friction between families, because basically I don't do claims back because I can't. I struggle with it, because what I have seen the Native Title Act done and the process does is it basically puts your identity as an Indigenous person through the ringer. You have to be able to prove who you are, where you come from, your understanding, your connection, and you are scrutinised by non-Indigenous people for your understanding. And if you don't have enough evidence to show to meet their threshold, then you may not be included in a particular claim group, which under your, through your whole life, your identity, your parents' identity, your grandparents' identity, that's who you understand who you are, but that doesn't actually fit within the mainstream recognition or process. And that in itself causes issues, because you'll have families who everyone accepts as being part of the group, because they do not have enough evidence, their family or their ancestor won't be included or recognised, and they will be left out of the determination. So there is a nasty dark side to native title, and it causes massive trauma within families, within groups, that it will take generations to heal. So
I think about Future Act stuff, so we'll move on from
we
that.
haven't talked about that.
Juicy.
yours. So Indigenous land use agreements. So most this is a type of agreement or contract that is a special type of contract because it exists under the Native Title Act. You only get this type of agreement because it actually comes out of the Native Title Act. And what it is that it is a voluntary agreement between a native title group, whether that's a claim group, a native title determination with their PBC, or a combination of both. You can also have an ILUA over an area where which what we would call an unclaimed area, where there is no registered claim and there is no registered determination. That is a lot of hard work, but you can do it. So it is basically an agreement about how to use and access the land and waters that the agreement is intending to cover. And what it will set out is what the thing is that you are wanting to do, what the consent is that you are asking the native title holders or the native title claim group to agree to, and what compensation you are offering for that consent. That's kind of it in a nutshell. Now, the interesting part about an ILUA is that it's a special type of agreement that once it is registered on the National Native Title Tribunal's website, it actually binds all parties, but it also binds every single native title holder to that agreement. No other type of contract or agreement can actually do that. This does that because that's what the Native Title Act says it can do. Is that clear? Yep. Next slide, Josh. Okay, so ILUAs can basically cover whatever you want. They can be about a future development. They can be about how native title rights and interests might exist with the rights of other people. For example, a pastoral leaseholder. So, as you're working up to your determination, you might do an ILUA with pastoral leaseholders to say, this is how we're going to use, how our rights are going to coexist together over, your pastoral lease area. It may include, and then it would just be setting out, how the parties have agreed to do that. It can be talking about access to a particular area. So you might have an area that is exclusive native title and somebody would like to arrange access. So it could set out the access process or protocols. It is also one of the only ways in which you can extinguish native title. So in the event somebody needs to do, normally this is done in big projects. And that is normally because there's a requirement for the financier of the project to have secure tenure. And the securest form of tenure you get is freehold. So there might be part of a project area that has native title on it. And in order to get freehold, they need to extinguish the native title. Now, when you extinguish native title, you actually have to offer compensation. So compensation does not have to be monetary. It could be a land swap. It can be whatever is agreed, but it doesn't have to be just money. ILUAs always include a compensation element. They normally include employment and other economic opportunities as part of the negotiation and outcome process. Now, you can include cultural heritage into an ILUA. And the reason you would do that is because under the Native Title Act, under the Cultural Heritage Act, if you have a project, this normally happens on big projects, big infrastructure projects. Because under the Cultural Heritage Act, if your project is of a nature that requires an environmental impact statement, so an EIS, you have to do a mandatory cultural heritage management plan under Part 7 of the Cultural Heritage Act. You've got no choice, you have to do that. However, if you do an ILUA and you include into your ILUA cultural heritage provisions around the management, avoidance and protection of cultural heritage, you tick the CHMP process, because that's the only other way you can get your compliance under the Act is either under a mandatory CHMP or you include it in an ILUA. So for those guys who did big infrastructure and mining projects, you normally get one agreement that covers everything they need for their native title and cultural heritage compliance. Is that clear? Any questions on that before we move on?
Has anyone had any experience with ILUAs, particularly relevant to planning, for example? So a planning scheme preparation, or it might even be a development application or something like that. No? Yeah, as Cassie said, they can be quite wide ranging, and most of them, I haven't ever come across one that had particular implications for planning. But that's not to say that they aren't there or that they can't occur. But something else that's relevant too, and Cassie may cover this a bit later, is that they're usually confidential between parties. So we'll talk a little bit about how you deal with that when you.
Josh, I'll just add, in our experience, which we'll talk more about in engagement too, that there was an ILUA through the Yarrabah Town Planning Scheme. So Yarrabah was planning their planning scheme, and there was an ILUA between Yarrabah and the GMY, well, the native title holders at the time, pre-determination to transfer that land. So the landowner was essentially changing. So I think that maybe there wasn't enough consideration given to that ILUA during the planning scheme process, in terms of that there would be during that process that a new landowner, and then that probably also impacted on the consultation. But we'll talk more about that in the engagement session. But that was probably a crucial step that was missed in planning and engagement and consultation in our process.
Thanks, Helen. That's Whoops, I just muted myself.
So I think I'll just add more to that, just probably considering also and checking the register and or people you're engaging with to see if there's any ILUAs already in place that may also impact on your planning scheme or work that you may be planning to do, is really understanding if there's other ILUAs already registered in your area that need to be given consideration.
Yeah. Kathy, is there a register or a place where you can look at ILUAs or rights? So I may detail, but is there a register or something similar that actually lists ILUAs that are relevant to say?
Sorry, Josh, I keep losing you. Keep dropping out for me. So just try it one more time.
Is that better? Can you hear me?
Yeah, now I can.
Yeah. I was just saying, is there a register or somewhere that you can go to search for ILUAs? Obviously, the content is confidential, but a list of ILUAs.
Would you like me to show you now?
Yeah, let's do it. I think that might be a good way to lead into the morning tea. We've got about 9 minutes to go before that.
All right, hang on. I will bring it up for you.
I'll just stop sharing my screen.
Yep.
And put yours in.
Can everybody see my screen?
Yep.
Yes.
Yep.
So it's just making sure it's the tribunal website you can see. Okay, so what you would do is you come to the search the registers and applications. You click on that. And over here, you can search the Register of Indigenous Land Use Agreements. And it's as simple as if you know the ILUA name. So you can see in my drop down, these are different search terms I have used to find different types of agreements. You can search by ILUA type. So whether that's an area agreement or a body corporate. So the difference is an area agreement is the type of agreement you would use where you have a claim or it's unclaimed, and you use the body corporate type of agreement where there is a PBC. You can search by state or territory, and you can search by representative area. So there's some previous ones I've done trying to find the history of other registered agreements or subject matter. So I can show you, let's do local government.
So, Cassie, this now, but can you actually search by different local government areas?
No, you would do it by, let's say if we went by Queensland, if you've got a particular name that you want me to search, I can search that. And you could
Right,
limit it
so
by
there-
representative body area. So if we did local government area agreement with North Queensland Land Council and hit search, they're all
Oh,
the different types of local government iluas.
You'll see ours there, the Mundingapa Yidinji Gunganji local government ilua, like,
So,
oh, yeah.
and then the local government ilua. Yeah, you'll see those ones.
so you can see for
Cassie from Julie, who says, is there any way to get a definitive search by allotment to find all native title and ILUA considerations?
yep, you can do that either in Queensland Globe or you can do it by Native Title Vision.
Right, and where's native title vision
So
located? Is that
you will need to register with the tribunal. So if you come to their, see on there, this is their front page, and in their mapping services, you can hit Native Title Vision. And if you don't have access, you might have to apply to get a login details. But if we go Queensland,
just for those of you watching, just a reminder that this is all being recorded, so you know, you can always refer back to it. Even though this isn't in the slides will also be circulated as well.
so this shows you, it's an interactive map of the different claims and determinations in the area. And then you have a different layer list. So whether you wanted to do it by determinations or ILUAs, so you could do it by ILUAs, and then it will show you where all the ILUAs that have been registered are. You can then add, so this one, Queensland Globe, when you get in there for this, I think it's in the Society tab, they get their information from the Native Title Tribunal's website. So they talk to each other. So, and then there is, so you can then go up here in the search, and if you wanted to search for a name or a place, so we could, I don't know if it will work if I just do Cairns. So you could come down to Cairns, and you can see that there, it will give you your, what do you call it? Your key. And we'll show you what the different, so you can click on areas within the map and it will bring up a little, I suppose, pop out that tells you what type it is. So the name of it, the tribunal number, when it was registered, when it was lodged. And then you can, if you click on the register extract, so if you zoom in and you find an ILUA that's over an area that you're interested in, if you click register extract, it takes you back to the tribunal's Indigenous ILUA search. And then what you will get there, my computer has just frozen, but you get a map and then you can click ILUA register export and it gives you a summary. Hang on. I don't know if you guys can see that.
Yeah, we can see that.
So this is the extract. So this is what you can see. Now, when you lodge in ILUA, you fill out an application, and in the application, it sets out, you've got to say what information you want to be available on the register and what information you want to be kept confidential. So most of the time, you will say you are quite happy for the area to be described, contact details of the parties, and then down the back page, it talks to you. Normally in here, it would have setting out the type of consent that has been given. It also will set out, you'll then be able to see the written description and the map of the ILUA area. And again, when you click on them, it pops out to a new screen as well. But then when we talked about it being confidential, if there was something in particular you needed to know about the ILUA, then you would contact the parties on this page here. with what your question or inquiry would be. Now, as part of the every determination, as a local governments will negotiate an ILUA with the Native Title Claim Group, and it'll be about how the local government continue to provide its services as a local government within the area, and how they're going to work with the Native Title holders as a key stakeholder, and then they will work out, and it includes important things like they will have, notifications, involvement in important celebrations. There might be conversations around the use or the naming of streets. They might have involvement in the naming of parks. So from my little understanding of what the role of plan is in relation to planning schemes, some of the things that the whole of council has negotiated as part of the native title claim under the local government area may be relevant and important for you guys to understand, because it also sets out the aspirations of the group and the aspirations of how they want to work and interact with the local government. So, could be around the dedication of parks. So, the restoring or protection of sacred trees. It could be the inclusion of, I said parks, I said streets, important historical places. So there is a lot of things that are discussed as part of the determination from a local government perspective that as planners, it's probably a good thing to get your head around to see what commitments have been promised, because obviously it's a contract. So a breach of the contract, if you're not providing or following those commitments, could ultimately end up in a breach of an agreement and then end up in the dispute resolution process unintentionally, without even knowing that, these commitments are obviously in there.
Yeah. Okay, that's great. Julie's asked a question in there about can an ILUA be amended to include a new party? Just given the time is 10:40, and I think we said we'd do a 20-minute break now. Maybe Julie, if you wanted to have a brief chat with Cassie, or
well, I said
Cassie,
that one's like the answer is like you can't just amend it, like no, because there's a process that has to be followed. So you would actually have to do a whole new ILUA, even if it just says that the parties amend, the ILUA to include this additional party. There's a statutory process that has to be followed under the Act of what the ILUA takes place. The registering, an ILUA has to be notified. So depending on what type of ILUA it is, but it has to be lodged with the tribunal. It then has to be notified in the paper. And then once that notification period has finished, it then gets registered. So it's not just as easy as crossing a name off and putting a new one in there. There's a process that has to be followed.